So in 2010, the Supreme Court heard a case called Citizens United versus the Federal Election Commission. And this case involved the role of corporations in politics, in particular, what kind of money could move from corporations into the political process. And the particular issue at hand was something called independent expenditures, which basically translates into a form of political advertising that expressly calls for the election or defeat of a candidate. And up until then, corporations had essentially been prohibited from engaging in that at the federal level. Interestingly enough, at the state level, about half the states allowed it and half the states didn't. We can come back to that at some point. But at the federal level, corporations since 1947, the Taft-Hartley Act, and then aspects of some more legislation in 2002, basically kept corporations from making these kinds of expenditures or funding these kinds of ads. And what happened in 2010 with the court is they looked back to the mid-1970s when they had sort of talked about this issue, and it was really the difference between campaign contributions versus campaign expenditures. And back in the 70s, there was a very famous case called Buckley versus Vallejo, and we're not going to talk about any more court cases, or not many. And the court came up with a fairly controversial decision back in the 70s that basically said regulation of campaign contributions was okay, limits on what they call independent expenditures, not okay. Now, they basically were talking about individuals, but they weren't entirely clear. But the logic was set back there, that there was this big distinction in the court's mind between contributions and expenditures. And because you're talking about spending money on political speech, which in a democracy is actually something we care a lot about, that there shouldn't be any limits on that because it didn't have the same taint of corruption that contributions might. You know, I give you a check, I might expect something in return, right? But spending on the side, independent of the candidates, of the parties, was considered okay, and back then essential to political speech in a democracy, which is kind of what was at issue. So, but they didn't explicitly deal with this question about corporations, and so the laws that had been on the books were still in place. So, but when they finally explicitly considered this question in 2010, they said, well, you know, how is it that the logic that we developed back in the 70s shouldn't apply now? And so the result of this case was to allow corporations and by implication unions to make unlimited independent expenditures using what they call treasury funds. In other words, corporate money itself, or treasury money, or union money itself. And so this would allow corporations to spend money or give money to organizations that were engaged in independent expenditures, which is really a form of political advertising. And the media reaction was quick and severe. Well, the reaction was tremendous fears that this would lead to a tidal wave of corporate funding and therefore corporate influence over the political process. And there's also a certain misnomer out there that Citizens United was directly responsible for the creation of super PACs. Okay, that was not part of the Citizens United decision. That was just about whether corporations could spend money in this particular form of political advertising. There was a lot of political advertising that corporations could have funded before Citizens United. This just added another increment to what they could. So it was not a all or nothing kind of proposition with respect to political advertising. So it allowed for this new part of the spectrum of political advertising to take place, and it's what we call express advocacy.